Good morning, ladies and gentlemen. Welcome back to another episode of PLA. We've got 2 questions today and we'll jump straight into them. One is regarding an OTP and one regarding a lease agreement. Bruno, will start with the OTP, which is our offer to purchasers, and we will deal with a suspensive condition, right? So the question is, can the deposit, the payment of a deposit, so can we have a suspensive condition saying that it's obvious the payment of the deposit is a suspensive condition within the OTP? Yes.
Yeah. So it's very dangerous. It's very dangerous to mix up, confuse terms and conditions, because those are actually 2 different things. So a term of a contract is an obligation in terms of a contract that a person needs to adhere to. And if they don't adhere to it, it's considered to be a breach of the contract. And in the contract itself, more often than not, there's some kind of remedy for how that breach is going to be dealt with, right? Again, more often than not, that remedy is sent out a demand. And if the person doesn't fix their breach within X period of time, the contract is going to be cancelled, right? So for all intents and purposes, the contract is in existence. A person breaches the contract is cancelled, and now there's consequences following the cancellation. Suspensive conditions work differently. We enter into a contract together. There's a suspensive condition. This says, yes, this contract's binding, but the binding nature of enforceability is suspended until the happening of a certain event. So this is the trigger. If the event does not take place, the contract is not binding. In fact, it lapses and it is of no consequence, right? So why is this important? Why? Because people would be listening to me going, same thing, contract comes to an end, but it doesn't. Different consequence. If a person's bound by a contract and they undertake to do certain things, number one, the person who's aggrieved, so the person who hasn't breached, the good guy in this whole story, right? He doesn't, number one, have to cancel the contract. So the contract doesn't just lapse and disappear into some kind of void and no one to ever see it again. He's got a choice. He can actually enforce the contract. So some buyers that buy properties from sellers who later change their mind and don't want to sell the property anymore, guess what? As a buyer, you can force them to sell the property, and it's a pretty good application to do. And all my applications for that have been successful. So you're entitled to enforce the contract. So that's number one. Number two, even if you don't enforce the contract and you decide to cancel it, you're probably going to be entitled to some form of damages, because the guy promised to do something, didn't do something. Because he didn't, it cost you money, it cost you time, it cost you opportunity. You suffered somehow. Now you can sue and get some kind of compensation or damages for that said damage or suffering, whatever you want to call it. A contract with a suspensive condition doesn't work that way. If the contract lapses, everything falls away, performance is restored, you get your money back, he gets his money back, or whatever. If you gave him the cell phone you sold and you want it back, you take it back, you give the money, everyone kind of walks away. Parts ways, no harm, no foul, that sort of thing. That's the whole thing, right? Now, going back to deposits, can a deposit be a suspensive condition? Sure, it can. Do you want it to be a suspensive condition? Really depends on you. If the seller doesn't understand the difference between these two and it's drafted as a suspensive condition, the problem is that by virtue of not paying a deposit, the contract lapses. And now, why would you want that as a seller? You want the guy to commit. So the one term that shows commitment is the payment of a deposit. If you're making that a suspensive condition, you're losing the one commitment, the first commitment this guy is going to make. So is it suggested? If you're a seller, probably not. If you're a purchaser, why not? So it really depends on where you are in this, in the negotiation. What I can tell you though is don't let it be inadvertent, because some people use the word subject to and throw it around and not understanding possible consequences. And unfortunately, not every interpretation is the same. So if you go and put in a contract subject to payment of a deposit, not realizing by doing that, you're saying this contract will lapse in the event that a deposit is not paid. That is what it means. So be very careful on the wording that you use. If you intend it to be a suspensive condition, draft it clearly. Deposit to be paid, specific time period, specific amount. This is what happens if it's not paid. It's like set it out so that there's no interpretation issue. Can it be done? Yes. Should it be done? Your call.
Yeah, I agree. And I think particularly, when it comes to immovable property transactions and sales, we got to remember these are specific types of agreements, and they have clauses that sometimes just relate to contracts like that. They don't exist anywhere else in law, not really. So stuff like a roadwork clause, okay, that's something that's super important for something like this, because the roadwork is a clause that basically says if there's a payment of a proportion of a deposit and you breach the contract and I cancel the contract, I can retain that performance that you've made thus far as a pre-estimated damages. And I think that's so important for this particular conversation, because if, as you say, you use a suspensive condition in the circumstances, okay, that contract never comes into place whatsoever. So you can't rely on your roadwork clause, okay, and then you won't have a damages claim which is coming out of that. And that's one of the protections that is given to parties in a transaction, to make sure that the seller now doesn't go through the effort of this particular transaction and the purchaser just walks away. There's some meat for them. So I couldn't agree more, Bruno. Definitely depending on the which party you are in this transaction, there would be a benefit probably for your purchaser a lot more than your seller in the circumstances. But certainly you've got to keep that distinction to make sure, at least from a seller's perspective, you've got to protect yourself.
Sure. Yeah, absolutely. Yeah.
Okay. Well, there you have it, ladies and gentlemen. Thank you, Bruno and Nick, for covering that first.